yes, sort of, part of me is attracted to that, to the evil brilliance of it, and part of me, the sort of older, more sober part of me is like, oh God, that would be sucky if that was true. So, this was their thing. They said, well, we are going to encourage our customers to seek a license and apply our solution, and we will enforce our IP rights if that's what's necessary. So, basically this bites both ways. Whether you're a vendor or you're a researcher, you have to be really concerned about what these issues are because it impacts computer security overall. And, it's a serious concern. On the one hand, we want to protect what intellectual property is designed to protect. On the other hand, we don't want to get ourselves into a situation where everything is so proprietary that we can't deal with the public infrastructure, car blows up kind of issues, that we can't have access to patches and information about, how we can keep ourselves secure, that we don't, that we don't know these things. Okay, just a tiny little bit about free speech. Yeah, it deserves a minute. Free speech is our First Amendment. It's most people's favorite amendment. It's not necessarily my favorite amendment, but it's our most robust one still, so we have to give it credit for that. And one of the real questions is, how does speech play into this? Because a lot of the stuff that we're doing, and a lot of stuff that by either pointing out how voting machines are insecure or stuff that you guys are doing by saying, there's flaws in the Cisco router or RFID is insecure, is basically, and saying like, look, I'll show you, is basically speech. It's saying, this is for real, man. You got to pay attention to it. And so, as I said before, we treat code as speech. Some kinds of actions are speech. Burning the flag, it's an action, it's functional, but it also has a speech or a communicative element to it, and the First Amendment protects it. So how does the First Amendment kind of play into all of these things? Well, it's a relatively novel area of the law. We haven't really thought all that much or done all that much work about how the First Amendment and speech protections play into as a limitation on play into IP law, intellectual property law, or limit intellectual property law. And so we've been doing kind of a really bad job in many ways of making sure that there are robust speech protections in these areas. We've seen a couple of cases in the copyright realm, mostly I think because of the quixotic efforts of my boss, Larry Lessig, who really wants courts to begin to see that, copyright law impacts speech. And I think he's done while his court cases have gone sort of generally badly, I think he's done a great job of making judges more aware and making the public more aware that copyright is basically a limitation on speech and has to have, all the kind of review and limitations and restrictions to allow speech to flourish. What I think I've pointed out with these examples is that it's no less true for other areas of intellectual property law, and it's a concern. But no element, if you look at the defenses in these charges, no element of defense in these charges doesn't violate free speech or doesn't impact the transmission of information, regardless of how important it is. So I'm going to take questions. That's my current information, which I think maybe many of you have. And this is going to be where I'll be until the end of August. And then after Labor Day, I changed to my new job, and that's my new information at my new job. So I'm going to take some questions, and just raise your hand, and we'll call you. Any questions? Yes, sir, in the back. Can you say it just a little louder? I'm sorry.
Dynamically linking to binaries distributed by someone else and then patching them in memory, so not distributing your code. Would that be considered work? Under limitations on not using the original work?
Is your question whether linking is infringement or?
Dynamically patching someone else's code.
On whose machine? Okay, so someone else's code is on your machine and you're patching it. Okay, I think that would be fall under 117 program mods. I think that, and you would be saying I'm patching it to make sure it keeps working for me and it doesn't, mess me up. I think that would fall under 117. Now, mind you, I think like what have I read? Like there's 3 cases or like 4 cases in all of, software history on 117 and exactly what it means. But I think that would be pretty clearly under there. You're not copying anything, right? You're modifying it. Maybe it's a derivative work, but it's derivative and you're holding on to it. Now, it might be a different story if you patch somebody else's code and then you started distributing it and saying, guess what, mine is better because it's improved with this patch I wrote. Most of what depends on how much of what you're distributing. That wouldn't be as good. Yeah, okay. Yes?
The only thing I would say to that is but for the fact that it's actually probably violating the
Yeah, so that's a great point. Thank you. But for the fact that you may be violating the EULA, which might say, you can't do something like this. And so then my question is, well, if you're violating the EULA, does that mean that, guess what, 117 doesn't apply to you? You don't get to use that as a defense and now you're a copyright infringer? Or does that mean like, oh, you violated the EULA and they can try to go after you for contract damages? And then the question about contract damages is, does the EULA say, if you violate this EULA, you owe us $1 million? Well, contract law is filled with doctrine to control that, to make sure that people who enter into contracts aren't getting a windfall as a result of breach of contract. So, that's... What do you mean obligation? Like obligation to your company or obligation to him?
Obligation to him because he's licensing it and he expects a certain...
I don't know that that's true. I don't know that the vendor has a continuing obligation to us because, we know tons of vendors that sell you something and then they go out of business, right?
Right, but this is my point. This is something that in technology, computer cases I've never seen. How can companies have it 2 ways? I want to sell him the software because I want control over it. Now I don't want to control it anymore.
Yeah, so
It's like a rental car. If I get in an accident with my car because my brakes are worn, that's my fault. I should know to fix the brakes. If I rent a car first and the brakes are gone, I get in an accident, the person's responsible. Nobody has done anything else trying to get software vendors not to have both ways.
Yeah. So the question is, why is it so one-sided? It's like the customer has all the burden, and the vendor doesn't have to maintain the software or even assert to you that it's secure or anything like that. They can just sell you whatever crap they want, and then you're kind of stuck with it, and that's it. So why is it one-sided? Well, we're individual people, and they have, big companies that have a lot of money. That's one reason. Another, maybe more legit. I don't want to be Machiavellian about it, but that's the main reason. Another reason that maybe is a little bit more legitimate is, in a lot of, and this is an area that I feel kind of uncertain about what the answer should be. In a lot of areas where there's new innovation, and software is clearly one of our most innovative industries that we currently have, liability rules restrict innovation. They make companies worry about what they're doing, right? And especially if you think that not all of the greatest software we've ever had is made by, in fact, maybe very little of the greatest software we have is made by the Microsofts of the world. We also have great software that people use that's made by communities of people on open source or that might be written by like a single person. And so there's some worry about or concern about how to impose fair responsibilities on vendors or coders and yet also not cramp their style when they're trying to make something new. So, there's always been a lot of proposals about, imposing kind of some sort of tort liability on people who sell you crappy or insecure software, and that hasn't gone anywhere, mostly for the first reason I said, but I also think it's a little bit more delicate of a question of like, when is it going to, how to do it in a way that's not too oppressive. So, I agree with you that it's a problem. I don't think that the answer is particularly clear right now. And so, we always have, particularly in the copyright realm, we civil liberties people are always like, let the software go out there. Let's see what happens with it. Let's not impose liability upon it too soon, right? That's the argument we made in Napster. That's the argument we made in Grokster. And look what peer-to-peer software has brought us. Peer-to-peer has brought us VoIP, which is awesome, and all sorts of other stuff like that. So we've tried to really, and that argument for me has a lot of play. On the other hand, I totally agree with you. The people who are in the best economic position to make sure that software is secure don't necessarily have any economic incentive to do so, and as a result, the polity suffers, our public network health suffers, and that's sort of untenable as well. I'm going to move to this section. Any questions? Yes, sir, in the back.
So the Cisco thing about is when you look work by analogy at the Insurance Institute crashes cars, and they highlight structural deficiencies where actual physical damage can accrue to an occupant, and they publish ratings, and I don't think that they've been ready to be sued. So working by analogy, there are structural deficiencies in a product where monetary damages can accrue to a customer. And why can they get away with, the threats of the patent infringements, the copyright infringements, et cetera, to be successful with that, or is the veracity of those claims starting to erode? If I think I understood you to say a little bit earlier.
Well, I think the reason they're getting away with it is because courts don't understand software and the ways in which it's the same and different as cars. And I think it's also because, everybody drives the car and wants it to be safe, but the judges don't understand, why software is important to all of us and why the network health is important to all of us. And, it's just, you get into this realm where you're sort of arguing by analogy, and it's what analogy did they buy? I think that we're on a path. I just think we're really early in that path to understanding and being able to figure out the ways in which to regulate and the ways in which to protect. Like in my Hewlett-Packard case where, the guy was basically a guy who fixed Hewlett-Packard computers, and they said, well, you don't have the code anymore, so you're not allowed to fix them, and he, went and reverse engineered the code. It was very easy. It's like you type in the code and you just change where it just make it always true. Yes, that was the right one, and you just use the same program that Hewlett-Packard shipped him with the servers when he would buy them, right? So it's, just not that big a deal. And I said, it's like you sell you a car with a big padlock on the hood. And they say, you can't take this car to, the guy down the block to fix it. You have to take it to Honda. And if you don't take it to Honda, then you've broken the law because you've accessed our engine, which is inside, or you've cut our lock. That lock stays and belongs to us. And I think any judge would think that that was insane, right? But that's just not the way that the court actually saw it. Hopefully, as we get, better educated, and I think to some extent we're beginning to see some thoughtfulness about this, that problem's gonna go away. Yes.
It's a little off topic. In my position, I deal with our legal group quite intensively, so to speak, and a lot of them are not as adept as you are in your electronic law, right? They perceive it, see it differently, right? How that old mentality, so to speak. So my question is, outside of law school, is there anything you know of that security professionals can do or can go to as far as a resource or class, etc., to keep us up to speed on these types of topics?
So the question is, what can security professionals do to keep up to speed on these topics? I think mostly with the intent of being able to communicate better with the lawyers who are like your in-house counsel people or that kind of thing. It's something short of the horror of going to law school and suffering through that ordeal. And, I think that it's hard, but you can, and especially in this area, because it's, you're grabbing from various areas of the law